So let me tell you what I know, and then I'll obviously hear from Miss uh, Lomas and then Miss Montgomery. But on November 8th of 2024, this court heard a motion by the defendant regarding custody support and parenting time. After oral argument, this court found a threshold um, having been met, and the matter was referred to the friend of the court for an investigation and recommendation. I signed an order of reference on 221, and I believe, I'm sorry, I signed the order of reference on the day of the motion. Um, the fees were allocated to the defendant, actually. The friend of the court completed their investigation and recommendation with the court and filed it with the court on February 21 of this year. And the parties were given 21 days to object. And the date that time frame ran was February 6th of 2025. Plaintiff filed a proper objection on 212 of 25. Therefore, it is timely. So generally speaking, the next go around for this, as both of you know, is that this court must, by case law and court rules, schedule an evidentiary hearing. That is usually what happens. But what I ask everybody first is, and I'll start with you, Ms. Lomas, and then from Ms. Montgomery. Sometimes mediation is helpful in these cases to see if the parties can be brought closer together or together. But I never send a case to mediation when pending an evidentiary hearing, if the parties through their attorneys don't indicate that it would be helpful. So I will start with you, Ms. Lomas. Do you believe setting it for mediation prior to setting an evidentiary hearing would assist the parties in bringing this case to conclusion?
I mean, that's definitely an option, Your Honor. I just know there's a lot of contentious issues regarding the parents' abilities, each party. So I'm more than happy if mediation is amenable to Miss Montgomery and her client. I believe we can attempt that. However, if not, we can prepare for an evidentiary hearing.
Okay. Somewhat of a lukewarm response, Ms. Montgomery, to mediation, but your thoughts, please.
My client does not wish to do harm with the children and the mom. So if mediation is good, we're open to it.
Then I will, and it's, I think, back to this is your motion, Ms. Lomas.
That is correct.
Your objection. So if you would prepare an order referring this matter to mediation pursuant to MCR 3.216, and the parties shall be fully responsible for the cost of mediation. And if the parties cannot agree on a mediator, then you can contact the dispute resolution clerk here at the county, and she or he will give you a date to or a name of somebody. That's always kind of a guessing game when the dispute resolution clerk does it. One time the parties, both from Grand Rapids, were given a mediator in Southfield because they were next up on the list. So it might be wise to do that. And obviously you can put in the order if mediation proves unsuccessful, then the attorneys can contact my clerk via email, and we will get some evidentiary hearing dates set for for the parties. I also want to just make sure I note for the record, I've read the motion, I've read your response as well, with Montgomery, and if this matter gets set for a evidentiary hearing, there are pretty significant pre-evidentiary hearing requirements as far as briefs, witness list, exhibit list, and I don't want the parties to get tripped up on that. So really, it'll be sent out with the notice of evidentiary hearing if one is necessary, and please pay close attention to that, because that has a tendency to, if it's not complied with, then we start talking adjournments and witness preclusion, exhibit preclusion. I don't want any of that, okay? So thank you both very much. I think Ms. Lomas has another one with me.
I do.
Boy, you're not lucky either. You got the same quality as Montgomery. Thank you both, and have a good weekend, everybody, and that matter's adjourned.
Thank you.
Thank you.
This is a motion filed by Ms. Lomas's office relative to parenting time. I'm a tad bit confused on this case because there is a evidentiary hearing scheduled in 3 days, is there not, Ms. Lomas?
Yeah, Monday.
Yes, there is.
That is correct.
Okay. Then it was apparently the defendant's objection to the FOC recommendation that set all this in motion. I guess my question to you is, we have an evidentiary hearing in 3 days. Why would I entertain any type of parenting time motion until I hear some evidence first?
That is correct. I apologize for that. I'm not sure if it was just a scheduling issue. I'm not sure which one came first. So we are aware of the evidentiary hearing on Monday, and this one got scheduled for today. So I mean, just asking for parenting time in the off chance that the evidentiary hearing does not happen at this time. And that is our motion at this time.
Well, I'm going to ask you a question, and I don't mean to be flippant, so please don't take it that way, okay? But quite frankly, this was your client's objection, and your client, I don't know how long this evidentiary hearing will take. It's been, these things are brutal on a referee's docket, as Mr. Carpenter knows all too well. But the question I have is, obviously, your client can begin parenting time as early as next week if he withdraws his objection to it. Then the order enters and we get busy with parenting time. Just addressing the issue, I guess. But that's between you and your client. Mr. Carpenter, anything I need to hear from the plaintiff?
Your Honor, I know you don't want to hear about settlement negotiations, but I've been trying to get this worked out with Mr. Browning. I'm surprised it hasn't settled already. We seem to be down to some detail issues. I don't think we're going to end up presenting proofs on Monday. I think we're just going to work out some details and come away from this with a plan. I'm frankly surprised it hasn't happened already. But I don't think that there's anything that we can do today or anything we should do today, because we're going to have a hearing on Monday. And we're so close.
Ms. Lomas, are you going to be the attorney trying this, or will Mr. Browning?
It will be Mr. Browning. It will be Mr. Browning, yes.
I will tell you this. I was able to resolve a case with Mr. Browning earlier this week. So if maybe what we'll do is we'll meet first and run some shuttle diplomacy and see if we can't get this thing resolved. I don't know if you know Mr. Carpenter or Ms. Lomas, but he is a very good attorney and a very reasonable one. And I've always enjoyed working with Mr. Browning, and I look forward to working with you in the future. So I'll see everybody on Monday, and maybe we can work things out at that time. Until then, maybe you can shoot some emails to one another and see if this thing can't be wrapped up. So
Understood.
understood. Thank you. We'll talk to everybody
Thank
later.
you.
We're adjourned.
Okay, great. Thank you.